Welcome to the University of Maastricht program on the reform of international investment law. This program is supported by a Jean Monnet project. I am Nicolas de Sadler. In the course of the following interviews, we shall deal with a number of timely topics ranging from the ISDS to the integration of environmental and consumer concerns in investment law. A large part of the public has been increasingly skeptical about the soundness and the legitimacy of international investment law. What a better time to interview my guest today, who is a specialist of this international discipline and who has been publishing a monograph on the European Union and the reform of international investment law. I have the pleasure to invite Ivana Damjanovic to the Fondation Universitaire de Belgique here in Brussels. Welcome.
Hello, Nicolas. Thank you, and it's a pleasure to be here.
I would like to discuss with you the place that international investment law occupies within international law. Many scholars and practitioners are taking the view that international investment law is so robust that it can be considered as a legal discipline in its own right. However, in contrast to the law of the seas that unfolds around a major framework convention, UNCLOS, there are no global comprehensive treaties or framework conventions dealing with investment. In addition, currently, investment law spreads across 3,000 treaties. Is it possible to claim that such a highly fragmented legal field corresponds to a legal discipline in its own right?
Well, you're correct when you say that international investment law is fragmented, but nevertheless it is part of international law, more specifically international economic law. So international investment law sets standards according to which states should treat foreign investors, and these standards are set in international treaties concluded between states. What makes international investment law unique is an option given to investors to sue states before a tribunal which is independent from that state. But nevertheless, we are talking about the legal international law character of international investment law.
If I understand correctly, international investment law is a subset of international economic law. When you mention international economic law, the first thing that occurred to me, this array of WTO treaties ranging from the SPS, TBT, GATT treaties to the Agreement on Agriculture. Is there anything similar with respect to investment?
So there are no multilateral treaties as the ones you mentioned in the WTO. There is no multilateral investment agreement among a large number of states that would set both substantive and procedural rules in international investment law. So these rules are spread around different treaties. Nevertheless, there are similar standards across these different legal instruments, and there are two procedural treaties which have been concluded between a large number of states. In particular, the New York Convention on the Enforcement of Arbitral Awards, and even more importantly, the ICSID Convention.
You just mentioned ICSID Convention, so I imagine this is a multilateral agreement. What's the importance of that agreement?
So ICSID is an arbitral institution, a center which provides a forum for the settlement of disputes between foreign investors and states, and these disputes are settled according to the convention, ICSID Convention, as well as additional rules.
If I understand you correctly, ICSID provides a number of definitions. In addition, it regulates the procedure. However, the bilateral treaties do also define concepts such as investors, investment, and in addition, these bilateral agreements confer specific rights to investors. Am I correct?
So international investment agreements majority of which are what we call bilateral investment treaties, confer on investors substantive rights such as right not to be expropriated or fair and equitable treatment, right not to be discriminated, whether against domestic investors or other foreign investors, as well as a free transfer of capital.
You just have been enumerating a flurry of rights ranging from FET to expropriation. That being said, these rights broadly defined in these bilateral agreements or these multilateral agreements?
And that is correct. In particular, these rights were broadly defined in what we call the first generation BITs, bilateral investment treaties. So what happened is that rights had to be interpreted, and the substance of what exactly the content of that right is was determined by investment tribunals that were interpreting these treaties.
Given that each treaty provides for a forum, so to speak, provides for the creation of an ad hoc arbitral tribunal to adjudicate a case between an investor and a host state, are we facing a highly fragmented case law?
Yes, and that is one of the problems of investment treaty arbitration. So because the provisions were very broadly defined, different investment tribunals had to interpret them, and there are inconsistencies between these interpretations. What is important is that in investment law, we don't have one single court which would interpret or provide authoritative interpretation of these rights. So each tribunal would interpret rights. But again, what is important to emphasize is that the case law is very fact-specific.
So in contrast to civil law, commercial law, where the lawyers will plead firstly before a tribunal of first of instance, then they will lodge an appeal, and it will end up before a court de cassation. The investor will initiate its proceeding just before one single tribunal, if I'm correct.
Yeah, that is correct. But what we have to bear in mind is that we're talking here about arbitration. We're not talking here about courts. So investment treaty arbitration works according to similar rules that we find in commercial arbitration.
To sum up, there are no review mechanisms, there are no appellate courts.
That is correct. And in particular, we could say that ICSID functions as an autonomous system which is not subject to the control of either domestic courts or domestic law.
It seems to me that there are no shortages of controversies with respect to ISDS, and that being said, the system harks back to the early 1960s with the conclusion in 1959 of bilateral treaties between West Germany and Pakistan, followed by the conclusion of a number of bilateral treaties between Western exporting capital nations and importing capital former colonies. Were these treaties reflecting a post-colonial order?
Well, I think you could say that they indeed did reflect a post-colonial order, in particular in that early stages of the international investment law development. So there was a need to protect foreign capital in former colonies. So if you look at ISDS being included in particular in agreements like between the Netherlands and Indonesia, for example, in the 60s, or Italy and Chad, these were the first agreements that had ISDS.
I imagine that with the dissolution of the Eastern Bloc, the disappearance of USSR in the 1990s, a new generation of investment treaties appear?
Well, we're not yet talking about the new generation of investment treaties in the 90s, but nevertheless, this was the period when the largest number of investment treaties was concluded in line with that new global vision of the economic order. And then in the last 20 years, we've seen in particular developments in relation to case law. So a lot of cases, investment treaty arbitration, contributing to the development of international investment law.
We'll come back to these issues in the forthcoming interviews. Ivana Damjanovic, welcome again to the Fondation Universitaire de Belgique, and thank you very much indeed.
Thank you.